Good morning. My name is Professor MacDougall. Some of you have taken classes with me before. Some of you are brand new to my classes. And so I thought I would start the semester by explaining how this course will run and also some of the parts of how we will communicate with one another. So let's start by saying that this has been an unpredictable situation that's happened with the COVID-19, that we have all been blindsided back 2 months ago with turning our in-class, face-to-face courses into online, using skills that many of my students don't have, many skills that I even never was forced to use before. So we are going through a period of time where we are learning how to learn differently, and we are learning how to teach differently. Let me first say that in all the courses that I just finished teaching in the spring semester and the ones I am teaching in the summer first session, they are all going to be online. Now, there have been all kinds of disputes about what online means. But because we've been thrown into this, each professor decides how they will teach their classes right now. If in the future something like this happens again, I believe that we'll probably have a more uniform system and that all students will be trained on Blackboard. But one of the things that I found out and was pretty shocked about finding out when we went to online is how many of my students know less about learning online than I knew about teaching online. And as a result, some do not even have their own computers. Some have a computer shared by multiple people within their home who are also using it to work remotely, or younger siblings who are going to school remotely. And also that my students who are working long hours, sometimes helping with the support of the rest of their family or even their friends. Therefore, the way that this course will run is that the very first thing I have to think about is that every course here at CCRI has what we call objectives and outcomes, meaning what are we aiming to do during the semester and what are we hoping you have learned when this class ends. My goal is to meet those objectives and outcomes, to meet them no matter how I am teaching a class. And that's the most important thing. Unfortunately, the way I teach most of my classes is not how I will be teaching this, for the simple reason that we can't be face to face. So what I am going to do is a couple times during the semester now, and probably in a few weeks, and maybe one more time, I will tape a lecture. The lecture will bring us up to date, maybe answer some questions you've been sending, and I will send you an email with assignments, but I will post that lecture with a link to YouTube, so that as long as you have a phone or a computer, you can get access to the information on my taped lecture. Now, I'm doing that because I feel like that is the easiest way to ensure that all my students have access to all the material. But mostly the way we will communicate is by email. Every student, faculty member, and staff member at the Community College of Rhode Island is assigned an email through CCRI. And every one of you who are registered for a course, there is a Blackboard source for me where I can send out an email to the entire class. That's how I did my communication in most of my classes for the spring semester, and that's how we're going to do it for the summer. So what will happen is this class, if we were meeting face to face, would meet on Tuesday and Thursday nights starting at 6:30. And it would go for approximately 3 hours twice a week. It goes for 6 weeks. It starts today on May 19th, Tuesday, and it will end on Thursday, January 25th. And so I have written a schedule for myself that what we will do each week and what we will accomplish so that we are sure to accomplish all the objectives and outcomes that we would even if we were together face to face in a classroom situation. Okay, having said that, let me tell you a little bit about the course and the material. I am also sending to you a syllabus. The syllabus is going to talk about the course objectives and outcomes, which also can be found on the website for the Criminal Justice and Legal Studies Department on the homepage for CCRI. All my exams will be and always are essay exams. One of the things I always say though is that I never test you on things I haven't talked about in class. Well, we're not going to be talking about them in class, but the way this will work is in the book, I will assign reading for each class. I will assign, sometimes in the chapters, a question or a case and ask you to write something about it or answer a question about it. You will write, do those assignments. You will send me any assignments that are made. It will give you a due date and a time date that assignment has to be in. You really want to keep up with the work, whether it's the reading or the assignments or the tests, because 6 weeks flies by. Right now it seems like a long way until the end of June, but I guarantee you as we get going, it's nonstop. It's a lot. And if you keep up with it, it's very manageable. But if you get behind, there's a lot to catch up on. So let me explain. So if you have the text, when you get the text and it's online, the contracts course is in Unit 3. And it is chapters 11 through 19. The only chapter we will not be doing, because I'll weave that material into other lectures, is chapter 17. So that means we're covering chapter 11, 12, 13, 14, 15, 16, and 18 and 19. So that gives us 8 chapters in 6 weeks. I have mapped out how we will cover that, and I teach this every semester and I teach it every summer. So there's no worries that we can't cover the material. We can, and you have at least one advantage. Because this course is going to be mostly through email, so are the tests, which means every test is what we would think of as a take-home test, meaning that I'll send the test out. It will be an essay test, and it will be based on the work we have already done, and you will have access to your book, to your notes, and to my lecture notes that I've sent out for every test. The good thing about this is an opportunity to get a really high grade in a class, because you will be able to use all your resource materials that we have in this course to take these tests. So in that way, that's an advantage to you. We will have 3 tests this semester. None of them will be cumulative. They will cover the chapters as we go. And of course, there will be about 4 or 5 assignments based on what you're reading in the chapters, or a landmark case, or a question asked at the end of a chapter. All of this, I will direct you through what I send you in email. You will get pages of my lecture notes. You will get assignments. All of this will be sent to you so that you have all the materials you will need. Okay, so let's talk a little bit about, if you look at the beginning of Unit 3 on contracts and e-contracts, you will see chapters 11 through 19 and the titles of the chapters. Chapter 11 is nature and terminology, and that means of contracts. Then agreement in traditional and e-contracts. consideration, capacity, and legality. So the first 4 chapters are going to deal with the required elements of a valid contract. And you will learn that the required elements of a valid contract are agreement, consideration, contractual capacity, and legality of purpose. And we will be studying those and learning as each element has its own chapter. And then, of course, in anything we study in the law, when we study cases and the chapters are filled with cases, one of the things we realize is the only cases that actually go to court are the ones where there are problems. And so one of the things about many of the rest of the chapters are teaching us not so much more elements, but of the things that can go wrong. Why? So that we can understand when we read a contract, when we sign a contract, when we study a contract, any of those things, the weaknesses or strengths of a contract and what those pieces mean. Now, contracts law, you can hear my clock. Okay, so just to let you know, my daughter is filming this. I've never filmed before like this, and so she's going to edit the pieces, but just to make sure, that's what's going on here. I'm hoping that this comes out well and this works so that we do have some kind of feeling of contact. All right, so let me get back to contracts and e-contracts. And so the cases that come to court, or the cases that we read about in the chapters, are cases where something goes wrong. Now, every one of you, every one of us will enter into many contracts during our lives. In fact, if you think about it, you probably have entered into several contracts already. Contracts come in all shapes and sizes. If you have a phone, you have a contract for service, right? If you have internet, you have a contract for service in your house. Do you lease or own a car, and did you take out a loan? Do you have a credit card? Do you own a house? Do you have a charge card to Walmart or Target or wherever? All of these involve contracts. Now, I'm a lawyer. I spend my life teaching law and being in the courtroom. And yet, do any of us actually read all of the pages and parts of the contracts when we even get our phone, when we get a charge card? Probably not. And what happens? We find out about something in the contract we've agreed to that we didn't really either understand or know we agreed to when something goes wrong. And that's when we begin to argue, and that's when problems erupt, and that's when cases sometimes go to court because of that. One thing I want to tell you about contracts is I have a saying that assume any contract you sign, you're going to be held to the terms of that contract. You should assume that. Don't go into something and say, well, it says if my phone breaks that I owe them $10 million, but that'll never happen. Assume, because the courts assume, they start every case with the assumption that if parties signed a contract, it's a valid contract. And then they start to look and see, are all of the elements required here? Is there anything unjust or unfair? Or was there even a real contract? So these are the things we're going to look at as, excuse me, as we go through this semester. Excuse me. Okay. So that in the notes and the documents that I'll be sending you, including the link to this, is how we're going to start the course. So you'll see the syllabus, and I will change the syllabus somewhat because this is online. And I will send you your assignment. And I want to talk about, I'd like to just start with what I would do if we were meeting the first night. I like to talk about contracts and contracts law generally, rather than the specifics that we'll study throughout the semester. So the first thing I want to say is contract law is civil law. Contract law is not criminal law. Now that doesn't mean that there couldn't be circumstances where there was an agreement between parties for an illegal purpose. Let's say you hired a hitman and you had an agreement, a contract. That contract does not satisfy the 4 requirements of a contract. If you look in chapter 11, on page 217, where it says the elements and requirements of a valid contract, that last one, legality, tells us that the purpose of any contract must be a legal purpose. So hiring a hitman is not a legal purpose, and as a result, that contract would not be enforceable, which is pretty obvious. However, it would be a crime. So there could be an overlap in certain things like that, but for the most part, contract law is civil law. Now let's talk about what civil law is. First of all, in the United States Constitution, we are guaranteed the right to contract, to enter into legally binding agreements with others. It's up to the court, if someone challenges that agreement at any time, to decide if it's an enforceable contract. Also, you will learn that not all contracts are written. Oral contracts are allowed in many circumstances, but you will also learn that certain types of contracts by statute must be in writing. And if they must be in writing and they're not, you risk that that contract will not be enforced by the courts because one of the legal requirements has not been followed. Okay, but we're going to get into all those specifics as we go through the semester. What I want to do is talk about civil cases in general. So let's talk about burdens of proof. So in many other classes, especially if you've taken any law classes, you have studied burdens of proof. When we talk about that term, burdens of proof, burden, responsibility, proof, evidence, proving, convincing a court of something. Burdens of proof are the statutorily set standard to win a case. Now, let me just jump to criminal cases. In criminal law, there is only one burden of proof, and it doesn't matter if your criminal case is being charged with multiple heinous, serious murders, or if it is maliciously breaking someone's property. There is only one criminal burden of proof, and you probably have heard of it, and it's called beyond a reasonable doubt. Now, if a burden of proof in a criminal case is always beyond a reasonable doubt, that burden of proof, that standard, is the highest standard we have. It means that the evidence to prove a criminal case has to be much more convincing than you'll see it is in a civil case. The beyond a reasonable doubt burden of proof is only used in criminal cases, but all criminal cases. And I like to explain it in terms of percentages. So for instance, beyond a reasonable doubt in a criminal case does not mean a case has to be proven 100% certain. It doesn't mean whether the judge or jury is making that decision that they have to be 100% sure this person did this crime or they haven't met their burden, because that is next to impossible. Even if someone confessed to a crime, we don't know that they're not covering for someone else. And so beyond a reasonable doubt, although it's the highest burden of proof, I like to say it's about 90% certain. It means that all the evidence introduced at a trial must convince the jury or the judge, whoever is making the decision, that they are at least 90% certain that this person did this crime based on the evidence presented. And if they think, well, I'm about 80% certain, that's not enough in our system to find someone guilty of a crime. Okay, so let's talk about civil cases, because contracts is a civil case. In civil cases, there's the possibility of two different burdens of proof, okay? One is the most commonly used one, and that is called a preponderance of the evidence. If your civil case has to be proven by a preponderance of the evidence, we interpret that to mean that the evidence must show that what you are accusing or alleging that happened in your civil case, that your evidence has convinced the trier of fact, which will be either a judge or a jury, that it's more likely than not that this person did what you are saying they did. More likely than not. Think about 0% to 100. More likely than not means that if your burden of proof in a civil case is preponderance of the evidence, then you have to introduce evidence to convince the trier of fact at least 51%. It can be more than that, but at least 51% certain based on the evidence that this person did what you accused them of. In contracts, it might be you breached the contract. You didn't perform what you agreed to perform under the contract. That's the most common burden of proof in civil cases, including contracts cases. However, there is one other type of burden of proof in civil cases, and that is called clear and convincing evidence. Now, clear and convincing evidence, first of all, is higher than preponderance, but of course lower than the criminal burden of beyond a reasonable doubt. And so if your case must be proven by clear and convincing evidence, I like to set that at the percentage of, you have to be about 70% or more, but at least 70% certain that the allegations in the case have been proven by the evidence presented. That's what we mean by burdens of proof, the responsibility to introduce evidence to meet a certain threshold, minimum threshold, in convincing the trier of fact that whatever you have brought this suit alleging has been proven. Now, let's talk about that term, trier of fact, because we're going to hear that a lot. I use it a lot, and also it's in the book a lot. So I always have students every semester who think that every criminal case has a jury with a judge, and every civil case is not entitled to a jury. None of that is true. Both criminal cases and civil cases may or may not have juries, okay? So going back to that clear and convincing evidence standard, and I said to you, that's less commonly used in civil cases than preponderance of the evidence. You may be asking yourself, so if I'm working on a civil case, how do I know if the burden of proof is going to be clear and convincing or preponderance of the evidence? So here's the rule so you will know. The rule is all civil cases have a burden of proof that is preponderance of the evidence unless there is a statute that has been passed specifically stating that the burden of proof is clear and convincing evidence, okay? So now let's get back to this trier of fact. So that term trier of fact refers to whoever is making the decision at trial in a case. And that is always either going to be a judge if there is no jury, or a jury if there is one. And if there is a jury, there's still going to be a judge, because remember, judges have a lot of duties: keeping order in the courtroom, deciding what evidence comes in. I mean, they have all of these duties. If there's a jury, they're not going to be deciding, and we don't use the term guilty in civil law. We use the term responsible or liable. So in a civil case, we might have a judge, or we might have a judge with a jury. They're going to be listening to the evidence, whoever the trier of fact is, and they're going to be deciding if they believe the case has been proven to the burden of proof required. And if it has, in a civil case, they will come back and say that the defendant has been found liable, or they in some places use the term responsible. Okay, so that's burdens of proof. Let's talk about this idea of a free attorney. So many people, and so many of my former clients, believed that this right to a free attorney is for all cases, any cases. The right to a free attorney in the Bill of Rights in the U.S. Constitution and throughout each state is for criminal cases only. So that means if you have a civil case, one of the things that you must realize is that you are going to be responsible for hiring your own attorney. Now, can you represent yourself? You can. And representing yourself would mean you're going to be held to the same standards an attorney would be held to. The court can't help you. The judge isn't up there to help someone who doesn't have an attorney. So there is no free attorney in civil cases. That right is reserved for criminal cases only. What happens to someone who has been found liable or responsible in a civil case? Okay, so I'll be sending notes in the little later chapters about damages, but just to quickly review it here, damages in civil cases fall into two categories. And the first category is what we call legal damages or legal remedies. When we talk about that, we are talking about what most civil cases ask for when they're filed in the court if the plaintiff wins, and that's for money. So legal damages are where we ask for money. In later chapters, I'll break down all the kinds of legal damages in civil cases. However, we have a second category of damages or remedies in civil cases, and that is called equitable remedies. Now, where legal remedies involve asking for money if you win a case, equitable remedies ask for something other than money if you are to win your case. Now, what's a damage other than money? What would an equitable damage be? Well, think about this. We have what we call TROs, temporary restraining orders, preliminary injunctions, permanent injunctions. An injunction is, in a civil case, what we think of as a restraining order. It's usually some kind of cease and desist order. And that's not money. That's an order of the court to the losing party to tell them that they can't do something or they must do something. You'll also learn in later chapters when we talk about damages and remedies that there's something in an equitable remedy called specific performance. Specific performance is where you are requesting that the court order the person to do what they were supposed to do under the original contract. Now, you will learn later on, specific performance is something that judges do not like to order. Think about if you hired some expensive portrait painter to paint your children's portraits, and they call you up and say, I know we had an agreement, a contract, but I can't do it. and you sue them because you've now bragged to all your friends that this famous painter is going to do portraits of your children, and you've paid them some money. So you want to sue them, and you want to ask the court for specific performance. Well, the court in most cases will not order that portrait painter to paint your children's portraits. You know why? Because they will probably not be to the standard that you want because of the bad blood, because of the lawsuit, because of the problems between you. The court would rather order some kind of money damages to compensate you for the loss. However, you will learn that with the sale of property, there are different rules under contract law and property law. You're going to learn this semester that, first of all, for the sale of land, it falls under a requirement that it must be a written contract to be enforced. If it is a written contract, then it has all the elements, it's likely to be enforced. If it's not written, then it is likely the court is not going to enforce it. And so under that, you will see often when there is a contract, a written contract for the sale of land, and someone tries to back out because maybe they got a better offer after they entered into a purchase and sales agreement, you will see that courts will use specific performance when it comes to property. And one of the reasons is because every piece of property in the universe is unique. And even though some other piece might look just like that, it's not the same. And so we have seen many times where courts will order specific performance when it comes to a purchase and sales agreement of land. Again, we're going to get into that more specifically in later chapters. Something else I want to talk about when it comes to civil cases, and that's statutes of limitation. So what is a statute of limitation? A statute of limitation is a legal time limit or deadline that tells us how long we have to start a case in the court system. Not how long we have to finish a trial, but how long we have to start the case. How do we start a case in the court system? We start it by filing a complaint. Now let me explain something. Let's use an example of a car accident. So you're stopped at a red light and someone comes up behind you and rear ends your car with their car. And you had stopped, the light was red, it's completely their fault. In the state of Rhode Island, and all of these statutes of limitations are called statutes because you can look them up in the law. They are statutory. And there are very varied and different statutes of limitations depending on your type of case. So you always have to look up and find what is the statute of limitations that applies in your case. Okay, because it's a legal time limit and it's telling you you have this long to start a case in the courts formally by filing a complaint. So in most negligence cases in car accidents in Rhode Island, there is a 3-year statute of limitations. That 3-year statute of limitations is going to tell you that you have 3 years from the date of that accident to actually file a complaint in the courts in the state of Rhode Island. If you let that 3 years run out, you have missed your statute of limitations and will forever lose the right to bring that lawsuit. And in fact, that's legal malpractice, and your firm will be sued probably by your client for that kind of negligence that you caused. And how much will they sue you for? The amount you told them you would sue in the car accident. So it is crucial when you work on a case and a client comes to a firm that you find out what the statute of limitations is and when it runs out and how long you have. Now, think about it in a car accident. Why do we need 3 years? Well, there's a good reason for a 3-year statute of limitations. First of all, when you're in a car accident, even though you could file that very day if you wanted, you don't know the extent of all your injuries. And many times in car accident cases, you end up with soft tissue damage that worsens as time goes by. So what we will see is that during that free time, that time before the statute runs out, but after something wrong has occurred, you may be trying to settle it without going to trial, because trials are expensive. Civil and criminal trials are very expensive. And so statutes of limitations are crucial to understanding how long you have to file a complaint in the courts and stop that statute of limitations from expiring. Because again, if it expires, you have forever lost your right to bring that lawsuit. Okay, just a few more concepts that I want to talk about before we end this video. All right, so another term that we are likely to talk about and read about several times is the term precedent. Now, precedent, not president, P-R-E-C-E-D-E-N-T. Precedent, the root of that word is precede, to come before. We have 3 terms that go together when we study civil or criminal law, and it's precedent, and it is rule of law, and it is stare decisis. I'll spell that for you. That's a Latin term. 2 words, S-T-A-R-E, second word, D-E-C-I-S-I-S. Now, precedent, rule of law, and stare decisis are what we refer to in all these cases that we will be reading that have been decided in the courts. So first of all, think about a U.S. Supreme Court. The U.S. Supreme Court is the highest court in the land. When they take on a case and decide it, their decision must be followed across the United States. Everyone has to follow it, okay? And so when you get cases like one they've decided, that's why we do research, look them up, or that's why we study them in law. And we will study them in each and every chapter that we cover in contracts law. We refer to those cases as precedent. They've already been decided by a court, an appellate court, that has power over us. Now, not only does the U.S. Supreme Court have power over the entire United States, but each state has its own court system. And in that court system, in each state, they will have a highest appellate court. Rhode Island's highest appellate court is named the Rhode Island Supreme Court. Not every state calls its highest appellate court a Supreme Court. They get to name what they want to name their own courts. But the highest in the federal system is the U.S. Supreme Court, and the highest in each state is called their highest appellate court, and they name it what they want. And using Rhode Island as an example, it's the Rhode Island Supreme Court. All appellate court decisions are published, and we can look them up and we can study them. Why are they published? Because they are precedent. They have to be followed until and unless a court changes with a newer case on that same subject. Now, I said all 3 of those terms go together. So we know precedent is a case from a higher court that has appellate court that has power over us and has decided some legal case. And that precedent will be followed in later cases with the same issues. Stare decisis, it's Latin, it means to stand by a decision. Well, that's what we do with precedent. That's why we look up and study cases. You'll be studying precedent, some of them old cases, but they are still good law. They haven't been overturned with a more recent legal case before the courts. And so precedent, when we have precedent on a particular legal issue, courts are going to follow it, stand by that decision, stare decisis. And let's talk about the term rule of law. Many times we will hear people say, we are a country that follows the rule of law. Well, rule of law can mean two different things. In contracts law, anytime we are studying a case and I say to you, could you please tell me the rule of law in that case? It means I want you to read that case and know what the court decided and the reasoning, the why they decided that case the way they did. They will give you their reasoning. Why? Because if that's precedent and they're going to follow stare decisis and enforce that in cases with those same or similar issues, we need to know what that rule of law is. We need to know the reasoning of the court, why they decided that issue in that case the way they did. Because we know that more likely than not, when other cases with that issue come before the court, they are going to stand by that precedent. Now, does it mean that they can never change? No, it doesn't. But it means that over the years, precedent gets relied on, it gets accepted. It's not a statute, it's a court decision, an appellate court decision. And so we tend to follow those decisions, and the courts follow them, and it allows us, when we are researching and working on a case, to be able to predict how the court is likely to decide our cases by how they decided cases like ours in the past. Now, if we're talking about no U.S. Supreme Court case yet on that issue, but we're in Rhode Island and the Rhode Island Supreme Court has made a decision on that issue, if we're in Rhode Island courts, that's going to be precedent, stare decisis, rule of law in Rhode Island. But it's not going to be that in Massachusetts or California or any other state, because a higher appellate court who has power over them have not made that decision yet. But once the U.S. Supreme Court takes on a case and makes a decision, they're all published, as every appellate court decision is, because they are precedent. We do follow stare decisis and the rule of law. Okay. So those are some of the basics in first of all, civil law. And as we get more deeply into the chapters on contracts and contract law, you will see those terms pop up. And you will see a more involved discussion of those terms, both in the book and in the lecture notes that I send you as we go through this semester. Now, I want to also make some assurances to you. So because we meet at 6, or we would have met at 6:30 on Tuesdays and Thursdays, I just want to make it clear that you can send me an email, a question, whatever, at any time. The only thing that I do ask you is that assignments and tests be sent in on the day that they are due. But anytime you have a question, even though technically I'm going to say Tuesdays, Thursdays, starting at 6:30 to 7:30, I will have office hours. You can email me, you can ask me a question. But please, don't think that's the only time you can do that. If you have a question, if you're working on something, if I've sent out notes or you're reading something that you have a question about, feel free to send me an email at any time. And if I see that several people are having a problem with a particular concept or subject matter or case, then I will address it to everyone, not just the few students who might have asked me. What else do I want to say? I just want to tell you that if you haven't yet taken a course that has been turned into an online course, sort of because of COVID-19 and the emergency situation of keeping us all safe, I just want to say, we have been doing this now for a few months, and I have had great success with the classes. I taught 9 classes last semester, turned them all to an online class, and students had great success in them. I know it can be very scary and worrisome about, oh my gosh, how am I going to do this? I've never done this before. I don't like doing this. I'm with you. I get it, but I want to tell you, you can do this. 6 weeks, and this will be over, and you will have accomplished and have the knowledge that you would have had if we met face to face. I like to think as a teacher that being face to face, getting to know you, talking to you before and after class is one of the best things about being a professor. We have to give that up for a little while, but I don't want you to even doubt that you can't get through this successfully. You can, and I will do everything I can to assist you in doing that. I really, some of you have, I noticed on the roster, some of you have taken me before, but not online. Some of you have just finished what we did in the spring semester, and so you will see, other than these lectures periodically, you will see that it's going to run the same way as we did at the end of the spring semester. I'm with you. I know the stress of this. My stress is your stress is my stress when it comes to this class. I want to be sure that you learn in a format that you have access to. And that's why I'm not using all of the things yet on Blackboard. I will use some of them. And anything I use besides email, everyone will get email and can send the email. You should know that you need to send any documents or homework assignments or tests in a format that can be opened through the CCRI Blackboard format, which is usually Word as a PDF. If, like last semester, if someone sends me an assignment or a test and I can't open it, I will send you an email saying, the format you sent it in, I cannot open it and correct it. Please send it again in a different format. And we'll work it out. Don't panic. There's enough stress. We're heading into spring, although it's been a little bit chilly for spring. We're heading into spring together. There's many components to this: social distancing, lockdown, quarantine, all of this. But I want to encourage you that you need to reduce stress. You need to get out and get fresh air. You need to do the things that keep you healthy, both physically, academically, and emotionally throughout. You can do this. You've been doing it. You will be able to. I know that it can be very challenging, and I just keep encouraging my students to take care of themselves. That's the most important thing. You have a lot of responsibilities if you're working, if you're supporting a family, if you've got children. I understand it, and we will get through this 6 weeks and be successful together. All right, so that is the first taped lecture. I have also sent the link to this on YouTube with the syllabus and the assignment. I probably won't do another taped lecture for a couple of weeks. I'm going to space them out and send you assignments through the email. All right, welcome to the class. Oh, and by the way, for anyone who hasn't had me before, like I said in the beginning, I'm Professor Cheryl MacDougall. I've been teaching at CCRI for going on, 26 years now, 26 and a half years. And I love my job. I love my students. I love teaching the law. I grew up in Rhode Island. I went to Bryant College. I went to Pepperdine University School of Law out in Malibu, California. I came home, took the Rhode Island bar. My first job when I passed the bar was as a public defender. A public defender is the one who represents people charged with crimes who cannot afford an attorney. You work for the state. I did that for about 3 years. Then I went into private practice. Each year I was a public defender, I got an average of 500 new cases. And then I was in private practice for 15 years. I still periodically consult or take cases, but for the most part, for the last 5 or 6 years, I have strictly been full-time professor. I also teach at the Providence Police Academy, and so I have done thousands of hearings, both civil and criminal. That's why I teach both criminal cases and courses and civil. I have lots of courtroom experience. I was a litigator. I taught at a law school for a while, and of course have been teaching at CCRI for several decades. And so I live in Rhode Island, grew up in Rhode Island. I got married late in life. I have 2 daughters who are in college. Those 2 daughters go to URI, and right now I'm looking forward to the summer session and the rest of the summer. I want you to be well, stay healthy, take care of yourself, and just do your assignments and keep up with the reading. Get the book through the CCRI bookstore website, and they're all online, and we will use the book. You have to get the book for this class, as we follow the chapters in the book. All right, take care of yourselves. I look forward to seeing you, or maybe seeing you at some point, but not this first session, and also going through this course together. Take care of yourself.